The wish to love, to care, to smile and see you in good mood. In this wonderful morning, we, the Indrani College of Nursing Institution Innovation Council, organizes the first Impact Lecture series, which is going to be on types of IPR, patent filing and prosecution. And it's very happy to share you all the institution Council of College. That so this surely will create an awareness and skill on innovation and IPR among all the faculties and the delegates who are attending the conference. Happy welcome to all of you.
On behalf of Icon-Iic College of Nursing, I would like to extend my welcome to our respected. Yes.
Sorry for the interruption. Sir, there is some network issues. Here I would like to welcome our respected Chairman Sir C.B. Ramachandran Sir, Managing Director Mr. Raju Krishna in their absence, and I would like to extend my cheerful welcome to Chief Operating Officer Ma'am Dr. Vidya of Sri Venkateshwara Groups of Institutions. And also I would like to extend my cheerful welcome to our respected Principal Ma'am Dr. Professor Mallika Kannan, who has been backbone for organizing this program in a well-fitted manner. And also I extend my welcome to our Vice Principal Ma'am, HODs, faculties who has been the great support to organize this program in the well-fitted manner. And then lastly, I would like to welcome all the delegates, participants who are very interested to participate in this conference, and also for their interest they had been expressed for this series. Welcome you all once again. Now I welcome our respected Chief Operating Officer Ma'am to introduce the session and also the speakers, to felicitate the speakers of the session. Thank you, ma'am. Over to you, ma'am.
Good morning, everybody. Good morning, our chief guests for the day, the speakers for the day, Dr. Sheetal Chopra. So, I'd like to appreciate our team of faculty at the College of Nursing for arranging such a program on intellectual property. We usually think like great things, great ideas only can patent. So, but I used to say, whichever idea you like get into your mind, even if it's the smallest idea, smallest thing, for any innovative thing, what we do in our routine, away from that, a bit away from that, can definitely be patented, and that is an innovative idea. So, our speakers are here, and with your excellent ideas and your suggestions and your guidance, definitely our faculties would go diligently about this, making more patents and rights towards IPR and more innovative ideas. So thank you all and welcome you all for this wonderful day. Thank you.
Thank you very much, ma'am, for the words of wishes. And now I welcome our respected principal, ma'am, Professor Dr. Mallika Kannan, to introduce the first speaker of the session, Dr. Sheetal Chopra. Over to you, ma'am.
Good morning, one and all. We are really indeed proud to organize our first impact series in the IIC category. So I welcome wholeheartedly, I welcome one and all gathered here to introduce about the today's speaker of this session, Dr. Sheetal Chopra. She has got many credentials with her. So she's an industry professional with 2 decades of experience in public policy and government affairs. She's currently serving as director, IPR Policy Ericsson India. She's a registered Indian patent agent and an author of the book on patent agent examination published by Notion Press. Dr. Chopra is a resource person, Kapila, Ministry of Education, GOI and Mentor for Change, Atal Innovation Mission, Niti Ayog GOI. In addition to this, Dr. Chopra is a visiting faculty and trainer at various educational institutions, government forums such as All India Radio, National Institute of Intellectual Property Management, IIT, NLSIU, etc. She has been recently awarded with the prestigious award by World IP Forum on Power Women in IP. Congratulations, ma'am, and we are really proud of that. Besides being an industry professional, she also wears an academic hat. She is a honorary course advisor for IFTC TSC, which is an intellectual property talent search examination, one of its kind IP Olympiad. She has been instrumental in developing customized ebook for students of IP Olympiad that is suitable across disciplines. So, having such a credit, indeed, we are really proud, ma'am, to invite you as our eminent speaker, and I wholeheartedly welcome you, ma'am, for this first session.
Thank you so much. Indeed, a great pleasure. It's overwhelming to hear all this coming from your mouth. So, thank you for that honor to me. Let me know when you wish me to start so that I can present the slides.
Yes, ma'am. Now you can start the session, ma'am. We are
Okay.
all waiting for the white sessions.
Okay. Let me know. I just try to share
Yes, ma'am. You
a
can share.
window. Is my presentation now visible?
Yes, ma'am. It is visible.
Okay. All right. Thank you so much once again. I cannot see anything except my own presentation. And if there are anything that comes in the chat session, I'll request somebody in the organizing committee to keep a check on that. And first of all, also many thanks to Indrani College of Nursing, the entire management, CEO, SPGI, principal, director, professors, everyone from the management to have invited me here. Also, I would like to thank Vijay from Patlex Business Solutions for reaching out. Today's presentation is going to be very generic in the sense we are going to talk more about introduction to IPRs because I imagine that this is for the first time that you might be exposed much in detail about what intellectual property rights is. And this presentation has been prepared by, like you already announced in my, while you were reading out my CV, that I am also an honorary course advisor to IPTSC, which is Intellectual Property Talent Search Examination, and they host nationwide IP Olympiad on on intellectual property various domains. And this presentation has been prepared by one of their researchers, so I wanted to give the credit, and therefore the logo representation you'll see in each slide. A few disclaimers before we go ahead. I know this is being recorded. So this presentation has been prepared purely for academic purposes, and the presentation has really no connection with the opinion of my organization, and there are several organizations with whom I'm affiliated to. So this is purely as an author, as an individual, that we will talk about the facts of IP, their introduction, what all does it entail. And although due care has been taken to ensure that there are resources that have been put up, but if in case I may have missed it out, stand to be corrected at any point in time. And also, I would request that none of the things that we speak today should be taken as a legal advice, but purely for academic purposes. We are going to talk on 5 aspects. I think 4 of those, top 4, which is introduction to IPRs and the key highlights that we will have. We will also discuss about some common myths that people have. Also, some key learnings. We will try to do gauge into some of the case studies, and then how to commercialize your IP, because otherwise it's just a paper tiger. Before we proceed ahead, just a small hygiene check. Am I audible and visible?
Yes, ma'am. You are audible, ma'am. You are visible.
All right. All right. And also, may I request everyone else to maybe go on mute, because sometimes there is some echo in between. And also, one request, let's not do this as a monologue. Let's try to do this as a dialogue. Anything under the ceiling, whatever you may call, please feel free to type your questions. And I don't know who from the organizing committee management is keeping track of chats, but as soon as it comes, please stop me there, because I really love interacting more than just reading out the slides. It will be very boring for me and you both otherwise. So let's discuss it as we progress. This slide I have taken from Vijay's slide he just shared, and I definitely wanted to give a credit to this slide particularly, because whenever you talk about why IPRs is important, there has to be reason why you have invited me. There has to be reason for audience to be hearing me and other eminent speakers going forward. Um, and the reasons are several. It helps in building your assets. It helps you introduce you to a whole new concept of innovation and IP. I mean, innovation, creativity, IP is nothing new. We all know, at least, in our own domains, we always keep coming up with somewhat other new ideas. It's now more important to recognize those ideas and get them protected, and beyond that, get them commercialized and licensed out for the benefit, for the inclusive growth. It helps you earn a lot of revenue basis if your invention is good enough for the market, is good enough for the industry to pick up, is good enough to coordinate and collaborate with other academic institutions and with other industry partners to develop something which can create your own brand value. In fact, it gives me such a good experience when I was doing some research about how academic institutions are faring well in US and Europe. And it shows that the majority of the startups in those developed countries are actually emanated from the academic institutions only. It's not like somebody from the industry who was in the industry for many years started its own startup and became a unicorn. Nothing like that. Most of the startups in other developed world have actually been created from the academic institutions itself. And therefore, if you now look at the IIC's calendar that is published by MOE every year, they have started to focus more and more on entrepreneurship, about startups, about being Atmanirbhar. And therefore, now for you all to learn about IP become all the more important. It's not only good for the institution as a whole to learn about IP, it, not just that you will create new startups, you'll build a name, and you will have a better better name in the eyes of government, but also to help support your own faculties and students create something on their own, have their own name as the inventor, as an author in whatever is published, and then maybe help them create their own company. But overall, for an institution having more and more such projects on IPR, whether it's the one that you are doing now or other relevant, important things that you may do in the domain of IP, helps you increase and improvise your accreditations and rankings, as you all know. It also helps in promoting, making the CVs of those who are learning about this IP better. In fact, Ajkal, what is happening is that even in the industry, whoever is coming for applying for a job, most of the senior leadership is actually asking, do you have any clue about IP? Or have you ever undergone a training on IP? Have you understood what are the basic concepts and how will you be able to contribute to the company's growth? In fact, sometimes the question becomes very generic during interviews. Okay, and I've seen many professors who are really wanting to come out of academic institutions after working for many years and then join a corporate field. And there they are asked a question: how will you be able to contribute to the company's growth? And IPR becomes a very, very important uh, benchmark to help support, to help convince the corporate why they should take you. So if you are looking up to a bigger vision to develop your own, have your own startup, to maybe do some activity in collaboration with industry, maybe work in the industry itself, then you must focus on the entire set of lecture series quite intensively and ask more and more questions. So section 1 is about introduction to IPRs. Can someone tell me if I'm going all right? Is my pitch okay? Any inputs will be helpful.
Yes, ma'am. Your voice is audible, ma'am. Your voice is visible also. No issues, ma'am. We can continue, ma'am.
All right. Thank you so much. Because of this
Yes,
technical, we are all on, it's like digital era, so we need to keep asking if I'm still there with you or not. So therefore I asked. Okay, so we'll do introduction to IPRs, and we will discuss about different forms of IPRs, and there are quite a few of those. I have not posted or pasted everything in this slide, but the key ones that I think we should definitely be aware of. I have intentionally not included geographical indications because that's more for the communities, that's more for the government. But keeping in view that we have audience from faculties and students, I thought it may not be prudent to include for you related to IT Act or geographical indication or Biodiversity Act. I think these are important, but maybe we'll keep it for some time, for some other time. So we will discuss about patents, we'll discuss about trademarks, copyrights, industrial design, and trade secrets. There are certain basic differences that I have kept into this slide, and patents is more for technological invention. If there is any problem in the art, if there is any problem that exists as on date, and an inventor is enthusiastic enough to do R&D or to come up with any solution to those existing problems in a technical manner, then those inventions become part of a patent, and it's given for 20 long years. And 20 years time period starts ticking from the date when application for patent is filed. And therefore this 20 years is not like extendable as far as India is concerned, because we don't have patent term extension in our country. It's there in US, and I guess to the best of my understanding in Europe as well. For any delays that may happen from the patent office's side, the length of the patent gets increased by those many days. But it doesn't happen in India, so one has to be extremely careful that when a patent application is filed, within a proper time, there is a reply sent to the patent office. Within the stipulated time, you try to convince patent office why your invention is novel, it is industrially applicable, and why it is non-obvious, meaning something that you have done differently, which others uh, in the same position may not have yet done. Another is trademarks, and I think trademark is something that we all as individuals, as consumers, we keep noticing and we keep coming through it. For example, we know about KFC, Burger King, or Pizza Hut. So any distinctive name under which a person wants to trade, like trademarks, as the name itself signifies, it is the mark under which you do a trading, meaning you buy, you sell something, which can make your product appear different. I mean, different in the sense people are able to recognize what is the source of that product, who is selling. So if there is McDonald's and we see those golden arches we get to know that it's McDonald's over there, and you don't even have to know the complete spelling or something of that sort. So it's a goodwill that a person is able to create. And for college such as yours, its patents and trademarks, including copyrights, all three are extremely important. Um, and copyright is something which is mostly used for literary work, for musical, drama, or cinematographic work. And for you, your college, which is purely into nursing, the publications that are, the works that are published in different journals, in different platforms, there exists an automatic copyright. And therefore, copyright becomes important. Similarly, if after a few years from now, after doing an intensive research, if there is some product that comes in the market, usually in a pamphlet, there is a pamphlet which is created for consumers to know what this product is all about. It has ingredients, it showcases how to take that product, and several other things. Even copyright exists on those pamphlets as well. It has a specific time period, which is 60 years. After the author's death and until the author is alive. So it's for a very, very long period. Trademark, I forgot to mention the tenure of its protection. Unlike patents, trademark term is extendable. It can range, it starts for initial 10 years of protection, and then subsequently you can continue to renew it for 5 years. So it's like perpetual, if we may safely say, but copyright and patents, they will stop to exist after that time period is over. But for trademark, until the time you are in the market, you are selling your product, you can continue to renew it for 5 years. So this becomes very important for you to know. All these three IPs fall fit together to give you a complete ecosystem whenever you are creating something new, whenever you are innovating something new. Uh, Industrial design, we are going to discuss a bit more in detail as we proceed. This also has a very specific time period, and of course, it can be, it is primarily for the outer design, for the aesthetics, no functionality. The moment it comes with the functionality, then it becomes part of a patent, but not design. Let me just try to give you an example. Of course, it's non-nursing example, but from a generic example that we can talk about. When you go for a travel, you have that trolley, right? Trolley usually has, not trolley, let's say it's a bag, and you hold that bag in your hand and go for travel purposes. Tomorrow there is, so this is pure fit for design, how it looks like, whether that box has multiple zips within it. It's a pure innovation fit for design protection. But the moment you make it a trolley, you have those wheels, or you have that handle that makes it easy to push the trolley on the roads. There is a functionality aspect that has come in. Then it falls better a case for a patent, because there is some technical issue that you have solved by putting in those wheels and that automated handle that comes out. So we are going to discuss about more examples as we progress, but feel free to give any other examples that come to your mind, which you think or you may want to ask whether it fits in which form of IP. We also have trade secrets. Trade secret is very common in the healthcare sector as a whole. Besides patent, there is something which is kept secret, something which is kept, which is not noticeable by the world. For example, if I want to pick up a case from healthcare, more so from the chemistry side, suppose I'm synthesizing some drug in the company, in the R&D division, and I as an inventor know that in the range of temperature from 5 degree to 15 degree centigrade, it's only at 12.5 degree centigrade that this product will appear in a much better proportion. So I, as an inventor, will file for a patent application for that drug, and I'll say in the process that the drug can be prepared in the temperature ranging from 5 to 15 degrees centigrade. And that stands true because at every temperature, there is some component of that ingredient that gets created. but it's only at 12.5 degrees centigrade that it will be that it will be created in a best quantity. So that part might be kept as a secret by a company, by an inventor, but the range may be given. So those are the kinds of the secrets that sometimes are important for the healthcare sector to keep, and that retains that corporate a competitive advantage. So this was about very brief introduction to IPRs. And like I said, one single product can have several IPRs. For example, if you look at the bottle, the shape of the bottle will go as design for design protection. And if there is any functionality like how to open up the cork or some other functionality that is included, like a tap, which makes it easy to pour out, some sort of functionality that it might be fit for the patent, including the ingredients or the composition of this bottle as to what is in it, can go for a patent. And there is a trademark, the name under which that bottle with that ingredient that is sold out. So these and then there could be process of making that particular malt, let's say, that could be kept as a trade secret. So there are different sort of IPRs that may be applicable for a single product, but depending on what goes within what. So copyright is what we were discussing about. It's primarily for the publishing sector and for entertainment, for music, for gems and jewelry, for information technology, and there are a lot of derivative works. But what is most important for you is to look at the third part, which is the publishing, as to whatever are the research papers that you will publish going forward, whatever are the pamphlets that you'll make available for the public at large. So those are the important aspects of copyright industry that goes for you. Um, and also, I think we all must understand what is protectable under copyright. Its ideas are never copyrightable. It's only the way you express. And therefore, you would have seen that we have lots of movies that have a similar plot. It's like a girlfriend and two people, one villain and a hero. And there are entire set of so many such movies that you see. Um, it is primarily because everyone can get that idea, the similar idea. But its only difference is that how you express that particular triangle story that gives you a copyright. Similarly, expression in the form of journals. For example, somebody may have done similar research, right? And both the researchers may have thought of, no, it's not very worthy for patent protection. Let us only file for a journal publication. And one researcher is in US and the other is in India. And both have completely are from different academic institutions. They have never discussed with each other, but they ideated the same concept. Both of them can publish in the journal. They cannot call that, oh, you infringed mine or the other one infringed the previous one. It's because both of them worked separately, but it's only the expression that has to be different. You cannot verbatim copy someone's work, but if you have done your own work and your originality is what will be seen, what will be looked into. So it's originality versus the novelty. At this stage, I would like to ask how much time do I have? It shows 10:28 for me. For how long you would want me to take this up?
It is a 1.5 hour session, ma'am.
Okay, so 1.5 hour session, is it like if it's 10:30 now till 11 I speak and then we open the house, or how does it work?
Yes, ma'am. Yes, ma'am. Till 11:10 you can speak, ma'am. Then we can open the session to the participants,
Okay,
ma'am.
and are there any questions in the chat box still?
Still now, we didn't get any question, ma'am.
Okay, right. I encourage you all to, yeah, I encourage you.
Yes, ma'am.
I encourage everyone to please start posting your questions, or even if it is comment, that's more than welcome. But do post something. Maybe any of the inventions that you are thinking about right now, or you may have example to share, do that, and then we can pick it up as we speak as well. So we don't have to necessarily make it, that I speak for another 45 minutes, but we can keep it interactive. So idea is not copyrightable. As I just said, it is the expression. Um, and there are two types of rights which are provided to the author. Can I request others to go on mute? There's some echo. So there is right to paternity and right to integrity. And these are two different sort of rights. For example, imagine that you as a professor or you as a student come up with a book, and that book is on some interesting topic in the nursing sector, on a particular disease or a particular lifestyle, and you publish it. Now there are two types of publications. One is self-publication and other is where you ask some third party to publish it, right? And you may decide, okay, I don't want to do a self-publication. It's way, too difficult. I don't have time, and I'll rather give it to some publisher. And you give it to him, and the publisher will sit with you, negotiate, and understand the royalty payments. Generally, it is between 15 to 20% that is shared with the author. In this case, again, negotiations might start, and you may, the publisher might ask you, okay, give me your entire copyright. And in that case, you may ask him that no, copyright will still vest with me. So both authorship as well as the copyright. Now people have become super smart. Now that they have learned about IPRs, they know that what I have created should continue to remain with me. At least I had this interesting, experience myself. When I published my first book, I ended up giving all my copyright to the publisher. It was many, many years ago, and there was less of the awareness about copyright, and I ended up giving it to the publisher. And then what happened, for every change in the book, if I wanted to change my publisher, if I was not happy with him, and if I wanted to make any changes in my own book for any updation, I would have to end up paying or at least seeking a permission from that publisher, because I ended up giving copyright to him. Later on, with the age, with experience, we learned that no, it is always good to keep your copyright with yourself, keep the authorship, and that's the right to paternity, meaning the publisher cannot at all take away your right. Even if you have ended up giving your copyright to publisher, he cannot take away your right as an author. Your name will definitely be present as who created that book. So be mindful of that, not to even give your copyright to the publisher, because I know in the healthcare sector there is mostly a lot of publication in the form of books that happen. So it's my sense of advice to you. Otherwise, you may have to end up seeking a permission from the previous publisher, even if you were to change a publisher from X to Y. They'll ask you for money or whatever. So this is the right to paternity, where you are a parent. You are the one who gave birth to the book and the content, and therefore your authorship shall always remain. Then there is also a right to integrity, which means that even if you have ended up giving copyright to the publisher for whatever XYZ reasons, maybe he was happy to give you 40% of royalty in return of, okay, you give me the entire copyright for a book, or some other interesting negotiation that may have happened between you and the publisher, but your integrity will always remain. Integrity, whereby it means that that publisher or that other party to whom you have given your copyrighted work cannot mutilate it, cannot destroy it, cannot change the contents so drastically. If I were to give you an example which is non-healthcare sector, then there was one mural, right? Somebody created one mural for government, and later on, after a few years, that mural was destroyed and it was thrown in the storeroom. And this author, he lifted his right to integrity. He said, no, you cannot mutilate my work, even if my work was for you, even if you paid me for this work. even if I have been given the entire money for which you hired me for a particular work, but you cannot mutilate or destroy it for my without my permission. And similarly, if I were to give you something from the Bollywood sector, you know, there are lots of copyright issues even there, but I think it may not be as apt for you from healthcare, but for a general consumer purposes, it may be okay for you to know about it. आपने वो गाना सुना होगा, मैं झंडू बाम हुई डार्लिंग तेरे लिए. So that झंडू word was used, someone's trademark was used, and that's how the company challenged that music director that you cannot use like this. It's my right to integrity. It's my work. How can you use my trademark for your song, which it doesn't even sound like very good. So these are the interesting factors that keep coming up when it comes to copyright. By far, in the entire field of IPRs, copyright for few experts sounds to be most interesting, because the kinds of examples that keep coming up in this sector are really interesting. And it's not very technical to even understand copyright. It's super simple, but it's interesting enough to be aware of, because then you can start connecting the dots. But be careful. There are two things that have to be taken into consideration, that copyright protection is automatic. You don't have to go to the copyright office to get your published journal, get a copyright protection. The day it has been created, the work has been created, it's published, it's your work. But it's good to still go and get a copyright protection, that number. It's because if tomorrow you want to challenge someone, or someone challenges you that this was not your work, then this copyright protection becomes important. It acts as a prima facie evidence to show that you are the one who created it. And it is automatically lost after 50 articles are produced. So copyright protection exists for so many years, up to the author's life, and 60 years beyond it, but only to an extent that not more than 50 copies are created. But now even this is being debated with the digital era. Automatically there are copies which are created by the author. Then would this 50 still remain to be an issue, is still being considered by a lot of policy experts. The second point I already mentioned, that registration is not yet mandatory because India is party to Berne Convention. It's an international convention whereby it's an automatic protection. You don't have to seek it, but it's good to have one in case, God forbid, if there is a court litigation or something of that sort. Now we progress to the other section of today's presentation, which is on the industrial design. And I think most of the things we discussed when we were talking about